People of the Philippines vs. Urquico et al. Facts. Accused Urquico and 3 others, including appellant Mandelma operating under Heyman Manpower Agency, had a series of transactions that involved the collection of money from at least 31 individuals who were looking for employment abroad. However, despite paying all the fees, none of these individuals were actually able to go abroad. Informations were filed for illegal recruitment committed in large-scale defined and penalized by Republic Act No. RA 8042 and Estafa under Article 315 Part 2A of the Revised Penal Code. The RTC convicted the accused while the Court of Appeals affirmed the conviction, but the penalty imposed by the CA for the violation of Estafa under Article 315 2A was an indeterminate penalty of prison correctional as minimum to prison mayor as maximum. Issues: whether or not all accused were guilty beyond reasonable doubt of the charges filed, and whether or not the penalty imposed for Estafa under Article 315 Part 2A of the RPC was correct. Ruling: as to the first issue, the prosecution was able to prove beyond reasonable doubt each of the elements constituting the crime of illegal recruitment of a large scale. 1. Regarding the first element that the accused undertook any recruitment activity defined under Article 13b, or any prohibited practice enumerated under Article 34 of the Labor Code, the prosecution was able to prove through the testimony of its witnesses that accused appellant was introduced by her co-accused as the job broker for Cyprus, Lathea Estefanos Stelios. Under this fake identity, accused committed various overt acts of recruitment. 2. For the second element, it was satisfactorily established that accused clearly did not have a license or authority to lawfully engage in the recruitment and placement of workers. 3. Lastly, the prosecution has established that there were at least 4 victims in this case. The Supreme Court also ruled that a person for the same acts may be convicted separately for illegal recruitment under RA 8042 or under the Labor Code and Estafa under Article 315 Par 2A of the RPC. Article 315 Par 2A of the RPC provides, Article 315, Swindling, Estafa. Any person who shall defraud another by any of the means mentioned herein below text XXXX2, by means of any of the following false pretenses or fraudulent acts executed prior to or simultaneously with the commission of the fraud. A. By using fictitious name or falsely pretending to possess power, influence, qualifications, property, credit, agency, business or imaginary transactions, or by means of other similar deceits. In this case, all the elements of Estafa are present. The testimonies of the private complainants, coupled with the documentary and object evidence, demonstrated that accused under the false pretense of being a legitimate overseas worker recruiter fraudulently induced private complainants to part with their money as part of the supposed recruitment process. Given that none of the private complainants was deployed abroad as they were just being scammed, they clearly suffered damage. As to the penalty to be imposed, the Supreme Court ruled that the penalty imposed by the CA was outdated. RA 1095191, which was enacted into law on August 29, 2017, already amended Article 315 of the RPC as to penalty and states that the penalty of arresto mayor in its maximum period to prison correctional in its minimum period shall be imposed, if such amount is over 40,000 pesos, 40,000, but does not exceed 1,200,000 pesos, 1 in 1,200,000. In this case, the total amount defrauded is P51,500, and thus, pursuant to the provision, the penalty prescribed is arresto mayor in its maximum period to prison correctional in its minimum period, as the amount is over P40,000 but does not exceed P1,200,000. Thus, considering that there are no mitigating or aggravating circumstances present, the penalty imposed by the Supreme Court was an indeterminate penalty of 2 months and 1 day of arresto mayor, as minimum, to 1 year and 1 day of prison correctional, as maximum.